speak on the second mic. Speak on the second mic. No, second, not that. No, end up. I want to see it.
Okay. Hello. So my name respondents, applicants, hello.
What a Saudi?
My name is
Saudi.
Malindi, respondents, counselor. See, how do you guys look yesterday? You were watching yesterday.
Yeah.
Greetings, and I heard you talking about me. Greetings, Your Excellencies. Greetings, Your Excellencies. I'm here to oppose the motion that Malindi is to be blamed of. Blame for the fires that happened. This is because of the case of Jonathan versus Hamptons.
That
doesn't work. It's not following. Hello. It's motion. It's following the motion.
Yes, now speak. Speak
Okay.
as kila mtu
Yes, but it's not following.
Get chini, please.
Okay. Armani. Yes.
Now speak.
Yeah. Hello. Hello. Yes. Dear councillors. Hello. Good afternoon. Good evening. Good afternoon. Hello. Yes. I'm here. Council.
Don't forget to be please.
So, good afternoon, panelists. Okay.
But you see, it's full. It's
Behind it.
So you use this microphone. Also get you the choose. See that new microphone. Yes, you can give me the microphone.
Felix, nataka nikwambie Felix, nataka nikwambie 6 minutes ama kwambie matete. Nataka nikwambie.
How many times you have to
kuna mwenye anachukua 10 minutes. Yote hakuna 10.
Andika.
Si lazima andike attend. Tunaweza anza 5 minutes kibaki na.
Hapana, si nikisema tunataka nini sinafaa kuinua. Nikuonyesha
Kuna start. Kuna imeandika start.
Hakuna imeandika start.
Tafuta karatasi za mpira.
Au unachukua 10? Naandika nyuma ya moja.
Unaweza kufanya nini? So you use 12. 12 8. Nikibakisha nitakuulizia.
Inasema start wana hawa bana.
Wengine ilikuwa hivi kufanya quarter. Nilikuwa nimeomba 10 kwa katikati. Then nikaomba 3 minutes hapo katikati ya swali. Nikaomba zingine 3. So nikimaliza kusubmit, then nikanunua 3 minutes. Nikasema niongeze sasa ile swali
Your mom Amen.
Don't miss the wisdom of sorry.
Ndivyo ndo wanasemanga.
Nikigeuza hivi sasa nikishaandika nyuma ya stop swali. Sasa nikifanya hivi. Nikigeuza na wambia stop.
we have to do those things. So let's not start with anger. Sasa kama umekuwa hapa
I never said can never. I just said the better the bad.
After mtu akiongea,
But you can have it with the money.
6 minutes.
Usije afanyike hivyo ndio.
Sivyo nafaa kufanya.
Na kuulize mtu anaanza kusema ikiwa
Leo wewe
so kuwa na 2 minutes. Inakuwa 2 minutes one
inakuwa 2 1 and then stop. It's following the motion. Like some of both, but mainly motion. So when you come over there, it shows the following the voice as well.
Inafuata method like people attracted to the method kwa sababu ya electric charges zinakuwa contracted.
Are you sure you're okay? What's up?
Sasa mbona jibu ni nini?
Jibu ni leo.
Unaona kesho?
Inaanza saa ngapi? Wengine tuko na tuko na exam Tuesday.
Ama is guidance?
You see, I just found it.
But that's because he
We're supposed to have a guest judge, but amekataa kuja.
That is why it's a guest judge. Kuna met the environment.
That's what I guess judge. I need to make
Washira unasikia? Kuna confirmation unamet the environment. You are one. My lawyer.
naona sichagua place ya kusiti. Sio tunaingia. Umechagua place ya kusiti. Kuna place ya kuandikia? Pole sana. Kuna place ya kuandikia? That's what I'm wondering.
Give your final.
Oh no. Out of 50, yeah. Out of 50, yeah.
Are you ready?
Then wasimame, introduce the matter, you see, the matter before us. The matter is this, and then you hand over the score sheets. All of the score sheets were there. And then you can tell the petitioner to sign. The petitioner should be his side. Who are the petitioners? Have you decided amongst yourselves once? You decided? Whichever. Have you decided amongst yourselves? Petitioners. Yes. Once you introduce them, between the three committees, yes, and two others. Yes, council Elise, are you ready? Kilons, that's why you guys are in the second round. Are you ready? And obviously, we're supposed to have a guest judge, but I think I told you. During the knockouts. Learning merits again.
Yeah. Your Excellency. Your Excellency. Your Excellency.
Council address them.
Done.
Address them. You're going to address them. I want to listen.
The presiding judge is Duncan Washira.
Address. I want to listen. I want to listen. Address. Okay. I want to listen. Please, we are waiting for. I want to wait for you to start. Okay, I just want to listen.
Tunaanza anytime now. Ngoja tunaanza nini kifanyika?
She's going to motion the matter. The day.
Right now.
I do not want us to get the bitch is not one. The bitch is
when you go to the court.
Unaona nikisema kwa introduction. Natumia 9. Mimi natumia 10.
this one is just news. Yeah, this was the one to give. What's on the agenda? The schools in the budget. Hi, one last test. Make sure that 23 minutes left without nothing. Higher. Now, I want us to check you how to speak because you need to be able to Zach, you need to be audible now this number. This one is the only one that is working. We've procured the batteries. Collins, so the only thing that we are requesting the audience, including the people who are spanning, is that you guys keep quiet. Considering we only have one mic, I wanted us to have 2 mics. Tumezunguka shule, I am tired, we cannot have 2 mics. Though we will have them tomorrow during knockouts. So at least there's that. During knockouts, we'll have 2 mics. However, for now, we'll actually have 4 mics after batteries zimeletwa na the school. But for now, we'll have to keep quiet, tupunguze sauti, because this is the only mic. It is recording every sound around us. So after your repetition, so you start. Once you're done presenting, see. Once you are starting, and then you guys need to be very audible now. Don't come the way right now it's following me. You need to be audible. Yes. I think that is all. Let me share this link. I will edit it. I will edit the first 25 minutes. And good luck. Oh yeah, they can't stay here.
The other thing is not.
The Rashanga, where is the other thing? Okay, so I will be there. So keep them out.
I can have my water. So I can have water here.
Kwani mara yako ya kwanza unajifanya itakuwa hivi.
Man, I feel so sick. Wow, I feel so tunaweza funga moot court na koji.
Oh, Akina Bill will be coming and taking pictures.
But see you movement kama
We just, it's just be, I'll be out here, so it's just be. Alafu mimi, what am I forgetting? No, I'm just advertising. I'm not actually watching. Advertising. Yes. But don't worry, this is the merit stage. We just want to know which team is number 1, number 2, number 3, number 4. This is the merit stage, so it's not knockout. Positive.
Yeah.
It's not knockout. You're not actually going against them. I'm a Silas at no, it's merit. So it is you impress them. So that when you're dividing you guys from number 1 to 4, we know number 1 will go with number 4, number 2 will go with number 3.
If number 1 goes against number 4, doesn't that mean that number 1 is proceeding automatically?
No, why?
Because
we are not taking any.
Last team.
No, like your memorial marks are standard. However, your oral marks are the ones that we are engaging. Today's oral marks will be different than tomorrow's. So if today you're number 1, tomorrow you might be up. There's a point knocked out. Yes. Depending on how well you count even your memorial. Yes. However, the merit counts your memorials.
But knockout is pure yours.
Exactly.
So that's the difference.
Yes. Oh, sorry, yes. Knockout is pure yours. Sorry.
Hiyo nani amesema?
You have to change because it will be.
Kwani hujanidanganya bado?
Danganya. Knockout is pure. Knockout is pure.
Knockout is since
Pure.
when?
Pure.
Since when?
Inakuanga hivyo.
Inakuanga hivyo.
Umefanya nini first mood?
No,
The
it's
first
not
mood
my
unajua.
first name.
No, the first mood. Unasemaje?
No, okay. In other competitions, I've seen that. Unakuanga not according to your orders.
Just
Do you have a
marking?
Do you have a marking sheet? Marking. Enjoy, have fun. Yes, have fun. Tafadhali, have fun.
And impress us.
Yes. Impress Duncan. Impress Duncan. Impress Duncan. Impress you. Okay. Impress Duncan. If you impress Duncan, we are good. Once you're done, please give the score sheets to the baby. Good luck. The baby, you're in charge of the form. Do you have any other questions?
Oh my God. That's why they get out and then you introduce them on the one.
No, they get out, then the baby says all right.
And then
Then
they
he writes
get
medication.
Si wangeingilia back
Sasa, you guys are dramatic.
You understand? Uko na recording nyingine yeah.
Let's see. I try, sorry.
Even the Supreme Court they did that.
Mimi nikoshua na news atakuja aseme kaanze tena.
And
Hata kama mtu kameenda kutafuta Anthony atakuja aseme kaanze tena. Mmepewa go ahead na Anthony? Mmepewa go ahead na?
amesema tunasikiliza. Hata edit. Kanasikia tukimsengenya. Na hii sasa sababu record bila microphone.
Look at me.
Nani alimwambia kusema?
All rise. The Republic of Malindi in the Environmental and Land Court at Nairobi, petition number 8 of 2024 between Kasiri Community Organization and 2 others versus the Attorney General and 2 others.
So good afternoon, council. My name is Washira Duncan. For purposes of this session, I'll be the presiding judge. So I let my co-judges introduce themselves. So we can begin.
Good afternoon. Good afternoon. My name is Nazarene Chimtai. I'll be co-judging this session. Good luck to all the teams.
Good afternoon, councils.
Good afternoon.
My name is Amani Andika. I'll be a co-judge. I look forward to hearing the submissions.
So just some ground rules before we begin. So each team has 20 minutes. So you decide amongst yourselves how you are going to divide your time. For the petitioners, we will give you 2 more minutes for your rebuttal for the petitioners only. We will have rebuttals. So I will request the bailiff to time you individually and pause your time when we ask questions. So we can give you, let us begin at 3:50. So you have 5 minutes to prepare, and we can have the petitioner, the first petitioner, begin from 3:50. Meanwhile, you can give us your team codes. So your team code.
Team code number 27.
Team code number 31.
Council, you have the team code again?
27.
So far. Council, whenever we are.
Whenever I'm ready. Just a question. Does time run from my introduction or does it run from my first issue?
It runs after you have introduced your
Greetings, honorable members of the bench. May it please the court. My name is Austin Nangamurezi, and I am the lead counsel appearing on behalf of the petitioners herein. With me, I have my co-counsel, Samba Deborah, and together we appear for the Kasiri community, for the Samira Environment Protection Group and Youth-Led Environmentalist Network, and Malindi Climate Justice Organization. We will use the time graciously allocated to us by this honorable court as follows. I will use the first 5 minutes of this honorable court's time to aver on the first issue that this court has jurisdiction, that the matters herein are admissible, and that the parties herein have local standard to appear before this court. On my second issue, I will use 5 minutes to aver that Salmur Limited is liable for the greenhouse gas emissions as well as environmental disasters that led to an escalation of climate vulnerability, leading to floods, leading to health impacts, and also leading to landslides. My co-counsel Samba Deborah will be using 5 minutes on the third issue, where it is our averment that the Republic of Malindi is liable for the transboundary harm caused to Samira. And on the fourth issue, she will use 5 minutes to address that issue, where it is our averment that the environment and social impact assessment was flawed since it failed to follow due process as well as public participation. We reserve 2 minutes for rebuttal, and thereafter she will conclude by stating our prayers. Will please the court, I wish to proceed. On my first issue, it is the petitioner's averment that this court has the requisite jurisdiction to handle these matters, that the matters herein are admissible before this court, and that the parties herein have local standard. I will address this issue threefold: on jurisdiction, on admissibility, and lastly on local standard. On jurisdiction, it is the petitioner's averment that this court has the requisite jurisdiction pursuant to Section 13 of the Environment and Land Court Act, which provides that this court shall have original and appellate jurisdiction to handle matters involving environment and land in accordance with Section 160, in accordance with Article 162(2)(b) of the Constitution of the Republic of Malindi. We rely on the case of Christopher Mulo versus the county government of Kitui in 2017 before this honorable court. In this case, my lords and my lady, it was held that the Employment and Labor Relations Court, the Environment and Land Court, and the High Court cannot have coordinate jurisdiction. To say that these courts have coordinate jurisdiction means that these courts can handle either matters involving constitutional rights, involving employment, or involving environment. However, it is the petitioner's submission that in that case it was held by Justice Amote that the jurisdiction of this court is pursuant to the Constitution of the Republic of Malindi, as well as the Supreme Court case of Republic versus Karisa Chengo in 2015. In this Supreme Court case, which is binding before this honorable court, it was stated that Article 165(5) of the Constitution of the Republic of Malindi precludes the High Court from entertaining matters which are reserved for the Environment and Land Court. This involves matters involving the right to a clean and healthy environment. It is therefore our submission that this court has jurisdiction since the matters herein involve the right to a clean and healthy environment. Hence, this court should declare that it has jurisdiction. On to my second issue.
Counsel, before you proceed to the next issue, admissibility.
Yes, my lord.
My question is, how does the court have jurisdiction on the third issue concerning what was already happened? And where does the third jurisdiction emanate either from the Constitution or the statute?
On that issue, my lord, it is the petitioner's government that Samira was harmed by the Republic of Malindi. Hence, it should seek redress before this honorable court. Hence, it is our submission that this court has jurisdiction pursuant to that argument.
So, which specific section of the Environment and Land Court Act are you citing in that regard?
Much obliged, my lord. I do not have a specific section with regards to that, hence I seek the indulgence of the bench.
Proceed.
On our second issue, it is the petitioner's government that the matters herein are admissible before this court. The matters herein are admissible since this court has jurisdiction. Pursuant to the fact that this court has jurisdiction, my lord, the matters herein are admissible. On to my
last one question on admissibility.
Yes, my lord.
Have you exhausted the local remedies? If you have the fact pattern review, paragraph, I believe 14. Paragraph 14 says, in case of a complaint by the people affected by the project, bracket PAP. I'm reading from the last line. In case of a complaint by the people affected into bracket PAP funded by the World Bank, the financial institution established an independent accountability mechanism that will receive these complaints and bring investigations toward the dispute resolution. So did you try that? And if yes, did you then proceed to the NEMA tribunal under section 129 of MCA before approaching this honorable court, and more particularly on the fourth issue concerning public participation on the process, on the MCA process? That is the environment impact assessment process.
Much obliged, my lord. With regards to that, it is the petitioner's government that, according to the case of Mohammed Ali Bani versus the Attorney General and 11 others, in 2018 before the High Court, it was held that for the obsession doctrine to be applicable, it has to be accessible, it has to be affordable, it has to be timely, and lastly, it has to be effective. In essence, my lord, it has to address the issues in totality. It is the petitioner's argument that, according to the case of Republic versus IEBC and 6 others, where it was stated that the exhaustion doctrine is not absolute. The exhaustion doctrine is subject to the exception that where there is a constitutional value at stake. Where there is a constitutional value at stake, then the exhaustion doctrine cannot be applicable. Then the exhaustion doctrine cannot be applicable in that matter. Hence, it is the petitioner's argument that pursuant to the Constitution, Article 42, we see that there is the right to a clean and healthy environment. The right to a clean and healthy environment in this case is the right which is violated. Hence, the exhaustion doctrine hence, according to the exception in the exhaustion doctrine, we could not have pursued another remedy.
What about the fourth issue? You know, the fourth issue concerns a process that is supposed to be done within the MCA Act. Everything that is done within that act, the tribunal has jurisdiction. Yeah, that matter. And in any case, the tribunal uses the principle of competence, their competence, to determine whether it has jurisdiction. So you should have approached that. And in any case, they say they do not have jurisdiction, then we should come here. So address us why the fourth issue, you did not approach the tribunal.
Much obliged, my lord. On the fourth issue, where the issue in contention is whether the environment and social impact assessment was flawed and violated the constitutional right of public participation, we submit that this right is intertwined with the right to a clean and healthy environment as enshrined in Article 42 of the Constitution of the Republic of Malindi. We therefore submit that this right is interconnected with the environment and land, hence it is admissible before this court, hence the matters herein are not subject to the exhaustion proceeding.
Address us on
Much obliged, my lord. On local standard, we rely on the definition of local standard according to the case of Alfred Jau as the City Council of Nairobi in 1989 before the Court of Appeal, where it was held that local standard is the right to appear before a court, the right to be heard before a court. To say that a party does not have local standard is to mean that this party cannot appear before that court. We rely on Article 70 of the Constitution of the Republic of Malindi, which states that where a person alleges that his or her right to a clean and healthy environment is recognized under Article 42 of the Constitution of the Republic of Malindi, has been, is being, or is likely to be violated, denied, infringed, or threatened, then this person has the right to appear before a court to seek redress before that court. Hence, the parties herein, as in paragraph 32 of the compromise, have local standard to appear before this court to seek redress for the violation of their right to a clean and healthy environment.
Council, your citation of Article 7, I'm not sure which specific grounds you're talking about under Article 70, but you talked about a person, but the parties before the court or the petitioners are organizations. So what do you have to say about it?
Much obliged, my lord. According to the Constitution, in Article 260, a person refers to and includes a company, an association, or any other body of persons, whether incorporated or unincorporated. Hence, the parties herein, who are the Kasiri community, Samira Environmentalist Protection Group, as well as the Malindi Climate Justice Organization, qualify under the definition of persons pursuant to Article 260 of the Constitution. My lord, on to my second issue. It is our argument that Talmud Limited is liable for the climate vulnerability which was spearheaded by the greenhouse gas emissions as well as environmental disasters leading to floods, leading to landslides, and leading also to the health impacts as seen in the area.
Council, before you proceed, I want to hear that your opinions. Do you blame the government concerning the issues of the floods and disasters taking place?
Much obliged, my lord. Yes, indeed, it is our submission that that Talmud Limited is liable for the greenhouse gas emissions.
I'm asking about the floods and the landslides.
The floods and the landslides, yes, they are liable for the floods and landslides.
But don't you think that the occurrence of the floods and landslides can be considered as an act of God, since that the government had no control over that?
Much obliged, my lord. According to paragraph 24 of the compromise, we see that Kiweni Conservation Group submitted warnings. It issued warnings to the Kasiri Cement project, Kasiri Cement factory, and it submitted that they were leading to the emission of greenhouse gases, which then led to the worsening of the climate change. It is our submission that according to paragraph 16 also, it was stated that by Professor Bakari that the area was not suitable. Yeah, my lord, according to paragraph 16, we see that the criteria of unforeseeability cannot be used. We see that it was foreseeable that acting on this land would have led to flooding as well as an economic disaster, as well as an environmental disaster as categorized in paragraph 16 of the compromise. It is our submission that the anthropogenic climate change was. It is our submission that there was anthropogenic climate change, which means that the matters herein were not unforeseeable since it included human activities. Hence, it cannot be held to be. Hence, it cannot be held to be unforeseeable. My lords and my lady, on my first limb of argument, it is our submission that Talmud Limited is liable since it failed to implement adequate adaptation measures leading to greenhouse gas emissions. According to section 13F, as read with section 20 of the compromise, as much obliged. According to section 20, as read with section 13F of the Climate Change Act, it produces an obligation. It produces an obligation for mainstreaming disaster risk reduction. And what this means is that you are supposed to implement disaster risk reduction in your project as by design, as opposed to as an afterthought. It is our submission that Talmud failed to do this, and we can see this in the complaint and the warnings issued by Kiweni Conservation Group. Much obliged.
Could you please tell the court on some of the precautions you have wanted the government to take, considering that this project was of great public interest?
Much obliged, my lord. Considering that the project was of great public interest, the correct avenue that they should have used, in essence, was public participation. They should have engaged the public and engage them in a manner that is meaningful. According to paragraph 19 of the compromise, we see that in Professor Bakari's EI's environmental and social impact assessment report that they had to find a compromise between comprehensive outreach and fiscal responsibility. They were doing this out of sheer formality. They were not doing this because they wanted to engage the public. As a matter of fact, we rely on the case of Replan B versus Secretary of State for Business, Energy and Industrial Strategy in 2020 before the Court of Appeal in the United Kingdom, where it was held that engaging in projects that do not mitigate or rather implement adequate measures for mitigation would, where we rely on the case of Replan B versus Secretary of State of Business, Energy and Industrial Strategy 2020 before the Court of Appeal, where it was held that the state by failing to acknowledge public participation as well as engaging in such an project that involved emission of greenhouse gas emissions, was held liable because it failed to engage the public. On to my second theme of argument, my lords and my ladies, it is our submission that Talmud Limited is liable since it failed to proceed, since it proceeded with the project even after the risk in the ESIA report was given. According to paragraph 16, we see that Professor Bakari categorizes Mirenga Valley as a soft ground in her environmental and social impact assessment. I seek 1 minute to conclude. Much obliged. According to paragraph 16, we see that Professor Bakari categorizes Mirenga Valley as a soft ground in her environmental and social impact assessment. According to the Environment and Impact Assessment Audit Regulations of 2003, we see that Section 4 provides that no proponent shall implement a project unless an environmental and impact assessment is taken place in accordance with these regulations. According to the second schedule, we see that there is provided for a criteria which, when implementing a development project, needs to be looked into intensively. We see that in this case, they failed to factor in the criteria that in paragraph 16, Mirenga Valley was classified as a soft ground, and that in relation to that, it led to the collapsing of cement factory in paragraph 30, and the ground shifting and swallowing miners as seen in paragraph 28. We rely on the case of NATO and 3 others versus the National Environment and Management Authority and another before the National Environment Tribunal in 2020. In this case, the second respondent failed to conduct the environmental and impact assessment report in accordance with the regulations. Hence, it was held that they acted unprocedurally, and as a matter of fact, they did not observe proper analysis of the impact and mitigation measures presented by the project proponent. It is therefore a submission that Talmud Limited is liable since there was no proper analysis of the impact as well as the mitigation measures, which then led to the collapsing of the mines and also led to the swallowing of the miners who are working in the underground mine. It is therefore a submission that it is therefore our prayer, in conclusion, that this court finds that it has jurisdiction, that the matters herein are admissible, and that the parties herein have no standard, and that Talmud Limited is held liable for environmental disasters by proceeding with the project even after the risk was given and it failed to implement adequate adaptation measures. With that, I cede the floor to my co-counsel.
Greetings, honorable members of the bench. May it please the court, as I have introduced, Samba Deborah is my name, appearing on behalf of the petitioners, and I will be taking 10 minutes of the honorable court's time to handle the last 2 issues, where, on issue C, it is our argument that the Republic of Malindi bears responsibility under international law for the environmental transboundary harm caused to the people of Samira. And to argue out our case, we shall use the following 2 lines of argument. First, it is our submission that the Republic of Malindi fails to apply the precautionary principle, or rather breach the precautionary principle, and therefore allowing harm to be caused to the people of Samira. The precautionary principle is a principle that influences policymakers to take anticipatory measures even when risks are uncertain. And we shall rely on the case of Tata versus Romania of 2009, which was decided in the European Court of Human Rights. In this case, the Romanian gold mining company had released sodium cyanide into the waters, therefore causing health risks to the people and the environment. A preliminary assessment test had been conducted by the Ministry of Environment of the Government of Romania, and it had laid out all the possible risks of initiating this mining company, or rather building this mining company in that area. However, the government of Romania failed to take precautionary measures to prevent these risks from happening, and they were therefore held liable under the precautionary principle. In the same way, the Republic of Malindi was told of the risks of initiating the Kasiri cement project in Virunga Valley, and they failed to mitigate these risks. According to paragraph 16 of the compromise, we see that Bakari's report categorized the land in Virunga Valley as soft land, and therefore there were the risks of causing, as it was categorized as soft land, and therefore the risk of experiencing floods, landslide, and ecosystem collapse was high. And therefore, we shall also look at paragraph 24 of the compromise, where Kireni Conservation Group issued warnings to the Kasiri Cement Factory on the amount of carbon dioxide that was being produced, therefore influencing climate change and causing an impact to the weather, and which would lead to adverse weather effects. On this, it is our submission that as the government of Malindi received these risks and warnings and they failed to act on these risks, they broke the precautionary principle, as this risk caused harm that was suffered by the people of Samira too. Secondly, or rather onto our second limb of argument, we shall rely on the no harm principle. This principle obligates states to refrain from activities that may cause harm to states or the people and environment of other states of other states. This principle was established in the case of the Trail Smelter Arbitration Case of 1941, which was decided in the International Arbitral Tribunals. In this case, it was held that it is the responsibility of states to protect other states from acts of individuals within its jurisdiction that may cause harm to these other states. According to paragraph 26 of the compromise, we see that the floods and the pollution that was being experienced by the people of Virunga Valley was experienced by the people of Samira as the flood waters were carried into the Azua Ocean, and therefore it caused effects to the people of Samira. We therefore submit that the Republic of Malindi had the responsibility of protecting the people of Samira from the harm that was caused by the activities from within its state. And therefore it is our submission that the Republic of Malindi will be held liable under the no harm principle. Having argued out issue C, I will be moving on to issue D. And
also, before you proceed to the topic, where are these principles and how are these principles applicable in the Republic of Malindi? So, from the Constitution, which section of the Environment and Land Code allows this court to rely on the precautionary principle?
okay, this case, first of all, the issue is whether they will be held liable under international law, and we are arguing out this case on the aspects of international law and the precautionary principle as well as the no harm principle and principles under international law, which are recognized, as I have stated, in cases, and also the precautionary principle is recognized in the Rio Declaration under paragraph 15, therefore obligating states to take precautions to prevent other states from being harmed.
So, which article of the Constitution says that those international principles are applicable in the Republic of Malindi? On which section of the Environment and Land Act says that this court should consider the precautionary principle of making decisions?
Section Article 2 of the Constitution recognizes
which clause? Article 2 clause.
I'm not sure of the class, but I know it is under Article 2 of the Constitution, which recognizes international laws that are recognized as part of the Kenyan law.
What about the MCA, the Environment and Land?
For the environmental and land court, I seek guidance from the court.
Address us on the issue.
Okay, moving on to the fourth issue. It is our submission that the environmental impact assessment test was flawed and it violated the rights of the members to public participation. To argue out our case, we shall also use the following three limbs of argument. First, it is our submission that Bakari's team failed to follow the right procedure in conducting the public participation process. We shall rely on the case of Mugo and 14 others versus Matiani and another of 2022, and it was decided by the High Court. In this case, the parameters of a reasonable public participation process were set, and these include but are not limited to: first, when conducting a public participation process, you should ensure that all the stakeholders give their views. Secondly, you should ensure that you get a wide range of views from the people in the community. Thirdly, you should ensure that you choose measures that are fit and efficient in the circumstances. And lastly, you should ensure that you conduct a meaningful process, which is not just a formality, but a way of listening to the people. And in assessing the way Bakari's team conducted the public participation process with regard to Mugo's case, we avert the following. First, according to paragraph 17 of the compromise, it is stated that Bakari's team reached out to only 47% of the members, yet they were required to reach out to 50% plus of the population. This meant that they left 53% of the population without information about the project and its impacts on the community. We therefore avert that by doing this, they lowered the quality of the public participation process, and they also conducted this just as a formality and not as a way of listening to the people. Similarly, under paragraph 19 of the compromise, on the last sentence, it is stated that some constraints made them to if I may refer to paragraph 19.
Council, as you refer us to paragraph 19, what is the test for public participation?
Okay, for public participation, there is public participation. There is no like one test, because in the case of CAPS Limited, CAPS Parking Limited and another versus County Government of Nairobi and another, it was stated that, in the case of, in the Moot Court Basin case, they cited a South African case which stated that the process of public participation is capable of infinite variation, and what amounts to a reasonable standard of that process surrounds the circumstances or is dependent on the circumstances of each case. However, the Mugo case, the Mugo versus Matiani, it stated what amounts to a reasonable standard, and this was also supported in the Moot Court Basin. And what, not a reasonable standard, but what?
I'm finding it hard to follow your submissions when you cite cases as Moot case, what case. What is the full citation of the case so that the bench can follow the legal authorities you are saying?
Okay. According to the Moot Court Basin Local Community and 15 others versus Permanent Secretary, Ministry of Energy, and 17 others of 2015 had by the High Court, they cited a South African case, which they cited a South African case which goes by the name
Allow me to make in the same case, the Moot Court Basin case, the High Court stated that the test for public participation is effective, and the 47% that was allowed to conduct public participation being termed effective.
It cannot stand to be effective because it is lower than the required amount of population, than the amount of population that is required to conduct the process according to the guidelines. It was stated in paragraph 17 that they were required to reach out to 50% plus of the population. And by reaching out to only 47%, it means that they were not effective in conducting that process.
According to which data?
It is stated in the compromise in the fact sheet.
But is that a legal provision or just some funds?
It
Is
is
there
some
any
funds.
legal provision requiring that you must meet 50 plus?
There is no legal provision.
So we would be right to say they did not violate any. So let me first of all clarify this. What type of project are they carrying out?
An environmental project.
According to the second schedule of MCA, is it a low risk project, a middle risk project, or a high risk project? Because first of all, the project has to be part of the second schedule so that you can see it requires the environment impact assessment. Because if it's not there, then it's not even a requirement. We can carry out the project without the impact assessment. So first of all, categorize the project, then take us to the regulations. The regulations, the 2 or 3 regulations, the regulations, 2 or 3, specifically regulation in 1917, which stipulates the requirements of public participation. And each specific one they did not
Sorry, specific.
Which specific requirement under the regulations 17, I guess, they did not meet with that.
Council, while you answer that, could you kindly tell the court on what other measures you would have recommended the government to take to ensure that more community members engage in public participation?
I'll start with your question, my lord. On which other measures we would have required the state to take? First, we look at the challenges that the people faced in carrying out the process. They state that they had a budgetary problem, they had a problem with the workforce. Therefore, we would have required the government to look into such things so that when public participation processes are being carried out, they should provide the right budget in accordance to finances for them to be able to facilitate such activities that they will be able to be reasonable and to satisfy the procedures of public participation. Yeah.
Continue to answer the preceding judge's question.
On your question, it is our submission that the project was a high-risk project regarding, or rather considering the risks that were involved in initiating the project in the area.
What about the requirements of public participation under Regulation 17 of the environment impact assessment and outreach regulations? And I request you look at the specific paragraph of the second schedule that you are talking about to classify the project. When you are doing that,
Much obliged, my lord, and I'd like to move on to with my submissions. Relying on Mugo's case and assessing the way the Bakari's team carried out the public participation process, it is also our submission that according to paragraph 19 of the compromise, they stated that they reached out to individuals instead of homesteads. We submit that this prevented them from getting a wide range of views from the people, and therefore it made the process ineffective and inefficient and will not be relied upon. On to our second, I seek one discretionary minute to make my conclusion. Okay. On to our second line of argument, it is our submission that the environmental impact assessment procedure violated the rights of of the members of the Republic of Malindi, as they were not informed of the risks that are involved in initiating the project. According to Article the right to information. According to Article 35(1)(b) of the Constitution of the Republic of Malindi, it is stated that every citizen has the right to information held by anyone, as long as it is important for the protection of a right of fundamental freedom. And according to the case of Caps Parking Limited and another versus County Government of Nairobi of 2021 that was heard by the High Court, it was stated that when conducting a public participation process, you should avail all the information necessary to the people and give them a chance to air out their views. Failure to do this means that the process has not met the statutory as well as the constitutional standard. Therefore, it is our submission that the Republic of Malindi, it is our submission that the environmental impact assessment test was flawed and it violated the rights of the people to public participation. As first, they failed to follow the right procedure, and second, they failed to inform the people of the risks that were involved in initiating this process. Therefore, having made my submissions, I'd like to say my prayers, where it is our prayer that the court declares that first, that it has jurisdiction to hear this case, and that the parties have local standard to appear before the court, and that the case is admissible. Second, we would like the court to declare that Talmud industry is liable for its contribution to greenhouse gas emissions and environmental disasters, particularly in escalating climate vulnerability of the region, particularly with regard to the floods, landslides, and health impact on the community. Thirdly, that the Republic of Malindi shall bear responsibility under international law for the environmental transboundary harm caused to the people of Samira. And lastly, we pray that this court declares that the environmental impact assessment process was flawed and that it violated the right of the people to public participation. And with that, I'd like to see the floor to the bench for further direction.
Council for the next one.
Greetings, honorable members of the bench. May it please the court. My name is Oware Felidea, the lead counsel appearing on behalf of the respondent. My co-counsel is Cyrus Karaoke, and together our team code is number 27, representing the respondents in this matter. I plan to use 12 minutes of this honorable court's time to address the preliminary issues under issue A, as well as issue D on public participation. My co-counsel will use 8 minutes to canvass our client's position on the merits of issues 2 on greenhouse gas emissions and 3 on transboundary harm. Unless directed otherwise, I will begin. Honorable members of the bench, desperate times call for desperate measures, and as a state and a government that comes face to face with apparent climatic conditions, members of the bench, and financial constraints, the state of Malindi has taken reasonable steps to ensure that it balances the competing priorities of pursuing economic development with environmental conservation. Therefore, the efforts of the respondents ought to be recognized and the allegations of the petitioners be done away with. The first issue brought before this court, the respondents assert that they indeed have local standing to stand before this court, and that the issues presented are inadmissible, and further that this court lacks the requisite jurisdiction to address issues C. Starting with local standing, it is our submission pursuant to Article 22, both 2C and D of the Constitution of Malindi that grants persons and organizations acting in public interest standing to constitute a court proceeding claiming that a right of fundamental freedom has been infringed, violated, or threatened. In action of response by the respondents in this matter, they are acting in public interest of the state and its citizens, and therefore they are granted standing under the said article. In matters admissibility, it is our position that issues C on greenhouse gas emissions and issue B on greenhouse gas emissions and issue B on the validity of the environmental, social, and impact assessment are inadmissible before this court for failure to comply with the doctrine on exhaustion of local remedies. Article 159 of the Constitution of Malindi mandates the judiciary to uphold alternative dispute resolution mechanisms. And in the case of Geoffrey Muthiga Kabiru versus Samuel Munga Henry, a case that was heard and held before the Court of Appeal, whose decision is binding before this honorable court, the court held that where an alternative dispute resolution mechanism exists, the same should be exhausted before the jurisdiction of the court is invoked. In contrast, pursuant to paragraph 32 of the fact sheet, once the petitioners felt that they were aggrieved, they failed to approach the National Environment Tribunal, which is empowered to hear matters relating to land and environment, which is the appropriate remedy that they should have sought. Since this is not what they did, members of the bench, issues B on greenhouse gas emissions and D on validity of environmental and social impact assessment are inadmissible before this court.
Before you proceed, is the National Environmental Tribunal endowed with powers to declare government policies unconstitutional?
Much obliged to answer your question, and I do take note of your concern that the National Environment Tribunal is not empowered to hear constitutional matters. However, we seek to rely on the binding Court of Appeals decision in the case of Mutanga Tea and Coffee Company versus Shikanda Limited in 2023, where the court opined that although alternative dispute resolution mechanisms or administrative remedies are not able to hear constitutional matters, they still need to be adhered to because they give rise to certain important rights, such as the right to fair trial. The administrative remedies in this case are empowered to carry out investigations, which are an important nexus in the administration of justice, seeking the redress of the court before first approaching alternative dispute resolution mechanisms or administrative remedies amounts to unfair trial of the side of the respondents.
Counsel, you note that jurisdiction comes either from the Constitution or statute. So you are saying that the tribunal had jurisdiction to clear those two issues. Now take us to the section of the MCA, specifically in section 129, that lists the jurisdiction of the tribunal, that says that the tribunal has jurisdiction to hear the issue of greenhouse gas emissions and the environmental impact assessment.
Much obliged, Honorable Presiding Judge. Section 129(1) of the Environmental Management and Coordination Act clearly states that the National Environment Tribunal has power or is empowered to hear matters relating to the validity of environmental and social impact assessments because there are issues on issuance of licenses. This is procedure that has to be carried out before a license is given. Also, they have power to hear cases on liability for environmental damage, which is the issue on greenhouse gas emissions, and therefore they have power to actually hear and determine these matters.
But you note the fourth issue is on whether public participation was properly done. Public participation is listed in a variety of articles of the Constitution. And it can emanate from Article 10, Article 70. Does the tribunal have jurisdiction on issues that concern provisions of the Constitution?
Honorable member of the bench, to reiterate the answer that I had given your co-judge, the National Environment Tribunal does not have power to hear constitutional matters. However, as cited in the Court of Appeals decision in the case of Mutanga Tea and Coffee Company versus Shikanda Limited in 2023, the court held that although tribunals such as the National Environment Tribunal cannot hear cases regarding constitutional matters, alternative dispute resolution mechanisms should still be followed due to rights that arise, such as the right to fair trial.
So, which alternative dispute resolution? Are you saying that we should have negotiated with Nazarene on whether they should stop emitting gases. That is, the community should negotiate with the company, yet even the company is unable to get to them. How is that negotiation going to be effective?
Honorable member of the bench, I take note of your concern on the impracticability of negotiations. But when you move with me to paragraph 40 of the fact sheet, we can see that an alternative dispute resolution mechanism was actually developed in the agreement that the state had with Internal Moot Limited. It stated that should there be any disputes arising, then the first point of call should have been to the independent accountability mechanism. The petitioners also failed to approach this remedy. There were two remedies, they failed to approach them, and therefore they are in violation of the doctrine on exhaustion of local revenues. If this court may allow me, I will move to the issue on jurisdiction and admissibility. Jurisdiction. Jurisdiction is everything, and without it, a court has no power to take even a single step. This was the holding of the Court of Appeal, whose decision is binding before this court, in the case of owners of the motor vessel versus Caltex Oil Limited. Further, the Supreme Court, whose decision is also binding before this court, in the case of SK Macharia versus Kenya Commercial Bank of Kenya, stated that jurisdiction of a court can only flow from statute or from the constitution or both. The petitioners have made a futile attempt to claim that this court has jurisdiction pursuant to Article 162(2)(b) of the Constitution of Malindi, read in conjunction with Section 13 of the Environment and Land Court Act. It is our assertion in these allegations that the said provisions are only applicable in the purview of the state of Malindi, and they do not extend to cover international obligations. As harsh and as new as this judgment may sound, you will not be lonely in coming to this conclusion, as your brothers and sisters in this honorable court, in the case of R versus Nyema ex parte Akaba Limited, held that the provisions that have been contemplated under Article 162, as together with Section 13 of the Environment and Land Court Act, do not extend where there has been an obligation of a state upon another state, and the principle of transboundary harm emanates from the obligation of a state to prevent causing harm to another state. Therefore, this court has no jurisdiction, and this court has no jurisdiction to hear and determine issue C. If you may allow me, members of the bench, to move to the fourth issue tabled before this court.
I'll clarify, is that a correct reading of Section 13 of the Environment and Land Court Act that says that this court has jurisdiction to hear all matters that concerns laws that environment and land laws that are applicable in Kenya, and in Malindi in this instance, and from my understanding, the petitioners cited only environment and land laws applicable in Malindi. So the court has jurisdiction here. That is Section 13(1).
Thank you for that question, honorable member of the bench. And seeing that the bench wants to deeply delve into this issue, I will seek 2 discretionary minutes to conclusively and comprehensively answer your question. Thank you very much for the generosity. Allow me to cite the binding case in the Court of Appeal of Kenya Ports Authority versus Modern Holdings Limited. The court held that jurisdiction is not a matter of referring from statutes, that is Section 13(1). Should the court or should the makers of law have wanted issues of international obligations to have been held to be heard in domestic courts, they would have expressly stated so under Section 13(1) of the Environment and Land Court Act. Allow me to also cite the case of David Ndii versus the Attorney General recently in 2021, popularly known as the BBI case, before the Court of Appeal, whose decision is binding before this court. The court held that international obligations, unless domesticated, expressly domesticated under statute, cannot be inferred or interpreted to have come from the statute. The said laws that are applicable to Kenya are only laws that are applicable to Kenya alone. There is a limitation on that legislation, Kenya alone. this is the state of Malindi and all member of the bench. In this case, for transboundary hub, we have the state of Samira and we also have the state of Malindi. These are two different states, and therefore the jurisdiction, should this court find that it has jurisdiction over these matters, it would be overstepping. Nevertheless, in the rare circumstance that this court finds that it has jurisdiction, the respondent is willing and able to address issue C. Moving swiftly to the fourth issue brought before this court, the respondents assert that the environmental and social impact assessment process carried out appeared to be processed and therefore upheld the right to public participation. We shall
first classify the project, then tell us which is the process that should have been followed, then take us to the specific provisions on public participation that are supposed to be followed when carrying out environment social impact assessment as per the regulations of the Act. Then with that we will have conclusively answered that issue.
Much obliged, Honorable Member of the Bench. Under the second schedule of the Environmental Impact Assessment and Audit Regulations of 2003, it is our position that mining activities stated under number 6 of the said scheduled regulations, mining activities are actually considered as a high-risk environmental project. Therefore, that is its categorization in this matter. For high-risk environmental projects, it is mandatory that an environmental impact assessment be done, and what amounts to an effective environmental impact assessment is given as per Regulation 17 of the Environment Regulations, or rather the Environment Impact Assessment and Audit Regulations. It states two things must be satisfied. First, under Regulation 17.1, we must seek the views of the people or the persons that are affected, and two,
the views of household member proceed.
Yes. Honorable Member of the Bench, I do take note of your concern that not each and every community member affected views was taken into consideration. However, I invoke the fourth requirement on what amounts to effective public participation as per the case of Mwiko Local Basic versus Permanent Secretary Minister for Energy. The fourth requirement states that it is not mandatory. The fourth and the fifth were read in conjunction. It is not mandatory in carrying out public participation that the views of each and every single person affected be taken into account. And also the petitioners tried to cite a South African case, and the respondents will come to their aid. It was the case of Nucleus South Africa Limited. But Council, under paragraph 17, you specifically overlooked 53% of the community members. So even if not all the views that were taken, at least everyone has to be accorded a reasonable opportunity to be able to conduct public activities. Honorable Member of the Bench, in the readings of the requirements, we do take note of the fact that intentional inclusivity has to be demonstrated by the respondents, and the intention of the government, pursuant to paragraph 50 of the fact sheet, before encountering these hurdles, is clearly seen in paragraph 15. It was our intention to ensure that we reach each and every community member. However, I would like to guide you to paragraph 19 of the fact sheet, where we can clearly see that we faced significant challenges. The topography, the rugged topography of the area, and the widely separated communities, putting into consideration that we had inadequate staff, members of the bench, was a hurdle that we had to overcome. Public participation, as per the third requirement under the Mwiko Local Basic case, is not a one-size-fits-all. It calls for innovation and malleability.
So, when you talk about topography now, I wonder because you are supposed to hold at least 3 public meetings according to Regulation 16. And in any case, you are supposed to give notices for at least 1 week and publicize the notices and the project. How is that affected by the topography if you use a newspaper? Is the newspaper affected by the topography? And you relied on the fourth and fifth test in the Moot Court Basin case. But what about the third test on the qualitative and quantitative? What does that test? Did you meet that test? Only met 47% and not 53%.
Also, counsel, when you answer that, the petitioners also submitted that you as the government should have invested more in the public participation. Bearing the fact that you faced significant challenges, so address us on that.
So when you talk about finances, remember you were given by World Bank more than $30,000 for the project. So you mean you have money for the project, but you don't have money for public participation?
And to respond to that, how do you balance comprehensive outreach and fiscal responsibility? Yeah, that's under paragraph 19.
Thank you, honorable members of the bench, for those really good questions. The rugged topography, clearly, member of the bench, is not enough for us to say that we did not give newspapers to these people. But I would like to reiterate the holdings of Robert N. Nakuru versus Minister versus the Governor of Kiambu County before the High Court. The court held that what matters, members of the bench, at the end of the day, is that a reasonable opportunity be given. And as cited in the case of Commission for Implementation of the Constitution versus the Parliament of Kenya in another, the court held that innovation and malleability is of utmost importance when it comes to public participation. The government is not, public participation is not a one-time occasion, members of the bench. It is a continuous process, as was held in the same cited case. When you move a bit to paragraph 19 of the fact sheet, we can see that under the report by Professor Bakari, they stated that they realized that certain improvements, members of the bench, and I will read it verbatim so as not to misguide this court. We realize that the improvements can be made in future engagements, notably in the transmission of risk-related information. Good faith is seen here, members of the bench. Since we do note that we did not accord the citizens all the information that is necessary, members of the bench, we still want to carry out public participation. We will still be able to do it, honorable members of the bench. And we do take note of the fact that we received a huge amount of money. But public participation, members of the bench, cannot be held to use all the money, members of the bench. We had to use the money in a prudent manner. We are a low-income developing country, members of the bench, and the state is trying. We are doing our best.
So council, does public participation after the project matter? You are saying you are going to do public participation.
As cited in
what essence is it to do public participation after the project is killing people?
In seeking 2 discretionary minutes to answer that question, it is of great importance for this court to note that unforeseeable events are the ones that led to certain deaths that are seen in the fact sheet. And my co-counsel will come and demonstrate that. It was unforeseeable, members of the bench. Public participation, as was cited in the case that I have mentioned before, members of the bench, was held that it is a continuous process. It does not end simply after the commencement of a project. It can still happen after, should there be any reports or recommendations that are given by the expert. So it does matter even after the project itself has commenced.
So what about the reasonableness? If you say people should be accorded a reasonable charge.
Yes.
So if the petitioners are saying the 53% were given no chance, not even a chance that is not reasonable, they were given no chance. So how do we do it? Or are you going to give now then chance after the project? Because I'm wondering if it's reasonable chance and you excluded 53, you can hold that for the 53 no chance was given, yet a rule unreasonable chance.
Honorable Presiding Judge, thank you for that question. The reasonability that we are seeking after is on the dissemination of information. On the population that was assessed, it is our stance that the population that was assessed in this case was sufficient. They were accorded a reasonable opportunity. Why? Because the petitioners, in seeing the respondents, in seeing all the challenges that they faced, chose to use a representative form of representation of the community members. It is just prudent, simple mathematics, member of the bench. If we are considering the head of households and the community leaders, obviously more than 53% of the population will not be reached, but they will be represented. The petitioners in this case have misrepresented or misread and misinterpreted the facts. Having reached the end of my submissions, members of the bench, we assert that this court lacks the research jurisdiction to hear issue C, that issues B and D are inadmissible before this court, and the petition and the respondent has longer standing. In issue D, it is our assertion that the environmental and social impact assessment process followed due process and therefore upheld the right to public participation. If that suffices the nature of my submissions, I would like to see the floor as well as 1 minute that I have remaining to my co-counsel to buttress the position of the respondents on the allegations made by the petitioners. Thank you.
Honorable members of the bench, my lords and my ladies, greetings and may it please the court. As earlier introduced and for the purpose of record, my name is Sarah Karaoke, the second counsel appearing on behalf of the respondents. I intend to take the 8 minutes allocated to me as well as the 1 minute donated to me by my co-counsel to dispense with the merits of the second and the third issue presented before this court. Unless the bench directs otherwise, I wish to proceed.
So on which basis are you submitting on the second issue where your co-counsel said you do not have jurisdiction on the issue of greenhouse gas?
Your Honors, to answer your question and your concern is noted. However, if in the event that this court finds that it has jurisdiction, then we are able and willing to respond to the petitioner's argument with regards to that issue. Your Honors, moving on to the second issue, on whether Tamu industry can be held liable for its greenhouse gas emission, environmental degradation, and for exacerbating the climatic vulnerability of the Kasiri region. It is our position as the respondent that Tamu industry and the respondents cannot be held liable. Your Honors, we will argue in 2 lines of argument. That one, the unprecedented floods and the disasters resulting thereof amount to an act of God, and therefore liability cannot be imposed on the respondents. Your Honors, the first counsel for the petitioners has stated that Tamu industry is responsible for the greenhouse gas emissions that occurred in Malindi. However, we wish to point your Honors to paragraph 22, where the respondents are seen to be taking steps to combat climate change with regards to curbing greenhouse gases, as well as paragraph 8, where the respondents have taken steps, adaptation and mitigation measures, such as reforestation and afforestation, to ensure that this issue of greenhouse gases is curbed. Further, paragraph 22 of the fact pattern paints a clear picture, Your Honors. We are taking steps and we have been able to trap and store 10,000 tons of greenhouse gas or carbon dioxide, Your Honors. Your Honors, this shows goodwill from the respondents that they are able and willing to combat the impacts of climate change with regards to the emissions of greenhouse gases. Furthermore, Your Honors, our country is a developing nation and we have contributed the least to global warming, having contributed less than 0.01 of the global greenhouse gases. Yes.
My little reading of the Bible tells me that God promised not to kill people again with floods after the Noah incident. And I understand now, reading paragraph 28, we can agree that maybe the floods are an act of God, but God promised not to kill people with floods. So there is an input that has been done here by the Tamu Limited, because A reading of paragraph 28 tells me that there are minors who are mining during that unfortunate, unprecedented rain. So, do you still say that the company is not liable for not taking precautions, even if we have unprecedented rain?
Thank you, Your Honor, for your question, and your concern is noted. However, in addressing your question, I would like to rely on the causation test, whereby the events that led to the death of the miners are attributable not to the thermal industry, but to the rains that occurred, your honors. We see from the fact pattern that rains occurred and they exacerbated the vulnerability of the land, seeing that it was a soft ground area. We therefore submit that for liability to be imposed, causation of the causal link has to be proved. And in this case, it has not been proved that thermal industry or the respondents were responsible for the death of the miners. Furthermore, Your Excellencies, with regards to climate change and our contribution to the climate vulnerability of the area, we submit that in the event that this court finds that we have contributed to climate change, we submit that the effects of climate change, as per the Intergovernmental Panel on Climate Change, the effects are seen after decades, Your Honors. And I will read in verbatim how they define climate change. And it is defined as long-term change in the average weather conditions and patterns that have come to